So, hello everybody. We saw each other just several hours ago. On Tuesday morning, I gave you a lecture on trade secrets, pretty rough and pushing to get it finished. I mentioned at the lecture one topic called LOI, Letter of Intent. And I didn't explain to you how it works. Therefore, I'm preparing this addendum so that those of you who are mostly interested in contract law might have a chance to understand what LOE is. LOE is the same abbreviation as COA, as Confidentiality Agreement, or NDA, called Non-Disclosure Agreement. It is a contract made between an employee and an employer, where the employer seeks to try to get his secrets pushed and protected. It might also be an agreement between two business parties, B2B, in order to protect one party against the other party stealing secrets. How it is done? I've provided some PowerPoint slides where you will find mentioned in the subtitles of my YouTube video. You can click the link and you get the slides. So, what are we talking about? We are talking about confidentiality measures necessary for protecting trade secrets under the EU Trade Secret Directive. Because the Trade Secret Directive has a view that the recognizable, merely subjective intention to maintain confidentiality, which was enough before the directive was in place, is not enough anymore. You need to do more. You have an obligation to take appropriate confidentiality measures. Otherwise, you would lose your protection of secrecy. Very important. What is necessary as an adequate measure depends on the specific nature of the trade secret and the specific circumstances of its use. In particular, it has been taken into account the value of the trade secret, the nature, the size of the company, the usual confidentiality measures in the company, and so on. These measures do not only include contractual protection, but also technical, physical access restrictions. So we have one case from the Regional Labor Court of Düsseldorf, which decided quite open and frankly on the 3rd of June 2020 that catch-all clauses are invalid. An agreement that simply declares all matters are secrets is not enough. That is very important because American advocates tend to say, oh, we have a secret. Everything is secret in the course of this business case. That's not impossible under European law. The dilemma is, of course, when you have to say what the secret is, you are telling details of the secret, and the other party will say, oh, that's very, very interesting. I didn't know that. That dilemma cannot be solved. So catch-all clauses are said to be invalid. You need to explain what the trade secret is, and you need a kind, I would call it a 3G plus model. You need an LOE, And additionally, at least a general data security model called TOM, Technical Organizational Measures under the GDPR. And you need, depending on the circumstances, you need more technical details for protecting the secrets. I have mentioned a lot of examples from Germany what these plus C2G plus might be. IT guidelines, prohibition on removing internal company data, a compliance system with clear audit possibilities and responsibilities, a regulation saying disclosure of information only for the person who need to know it and who are aware that they are subject of a confidentiality agreement, a prohibition on storing data on private data carriers without password protection. There's a big problem if you bring your own device. Employees working in a home office, that might also be a topic for secrecy arrangement. Let me skip all the examples, all examples for your work. And let's come to the letter of intent. In the letter of intent, I skip several folders. What you need in the letter of intent, you need to define the secret information and also trade secret. Then you have to define the confidentiality. What does confidentiality include? You can use the agreement to prohibit reverse engineering. I said to you this morning, reverse engineering is an open issue since the directive on trade secret allows, in general, reverse engineering to be made. You have to regulate reports of misconduct and whistleblowing was having whistleblowing, and you have to find sanctions for especially punitive damage. So, coming to the bullet points, you have confidentiality. You have to explain what is confidential, what is protected according to the LOI. That has to be defined very clearly. And you should not only regulate that the secrets are not disclosed to third parties. What else do secrecy means from technical points? You can exclude to a certain degree, which is highly questionable, reverse engineering. A clause could read as follows: the receiving partner also undertakes not to reverse engineer, decompile, and so on. You might try to regulate whistleblowing because that endangers your secrecy structure in the company. And we have to integrate a contractual penalty. And so there are always mistakes with the penalties because contractual penalties are not allowed in certain countries like United States or Britain. They are allowed in Germany, but you should not overestimate your fictitious penalty. So to say, I want to have 3 million euro money, that might be reduced by the court. They say this is too much. So it is very bad if the contractual penalty is grossly disproportionate to the significance of the infringement. So you can integrate a non-competition law because you have two dangers in secrecy cases. One is somebody stealing secrets. The other is the situation somebody is taking your employees and they are losing contact to a company, leaving a company and going to a new company. That might cause a lot of problems. Non-competition clause can prevent to a certain degree that employees are quickly changing a company, but you have to pay, at least in Germany, Austria, you have to pay compensation for the loss of earnings according to the Handelsgesetzbuch, the Trade Act. So that's very dangerous and very expensive to do it. So that is for me one quick survey on the dangers and the problems caused and solved by letters of intent. I hope this is now better understandable for you. Good luck, and I'm happy to see you in the following lectures.